Is that a criminal act, yes or no?
No, in fact, we stated...
So why did you deem it appropriate to monitor Cleta Mitchell's long-distance phone records in 2023, 2.5 years after the election contest was filed and after the presidential electors were certified? What about Jenna Ellis? What about Sidney Powell? What about Bill Sepien? What crime did you suspect had been committed by them? A federal judge just recently stated a prosecutor who continues to sign his name in court filings after a disqualification order should face disciplinary action or disbarment. Because frankly, are there any limits to the power of a special prosecutor or special counsel? So much so in your abuse of power that in the summer of 2024, the indictment involving classified documents was dismissed after determining your appointment violated the Appointments Clause of the Constitution. Am I on this list? Did you target my records and subpoena my phone toll records?
My understanding is your records were subpoenaed by prosecutors before I became special counsel.
Well, staff would put this up on the screen. I'm thankful for the great staff who discovered the email where I learned for the first time a few weeks ago that my phone records were indeed targeted. We called AT&T and we've learned that they were given to the Department of Justice, as this email indicates, because I have been in communication with Scott Perry, one of my colleagues here in Congress, who literally had his phone taken from him in front of his family. And of course, as we've already talked about in this document, it talks about you could be in violation of the privilege by even obtaining and possessing this information if the member objected to the disclosure. This happened 4 years ago in May of 2022, and I couldn't object because I didn't know. I didn't know until about 3 weeks ago. My question here is, was there any limits to your investigation or the investigation that preceded you, Mr. Smith? Because as egregious as a violation of separation of powers this is, as an egregious and abuse of power it is, it's far more concerning you are clearly targeting American citizens for merely being conservative or supporting the president. We've got memos that we've already been talking about in this hearing from April 2022 that preceded you that establish and open the investigations, one of which has Attorney General Merrick Garland's signature on it. And the focus was the electors. Now that was 6 months before you were appointed. You testified earlier, you met and interviewed Merrick Garland and Deputy AG Lisa Monaco. And you briefed the AG and deputy multiple times. Did you brief them on the electors and the prosecution of their supposed crimes?
I'm sorry.
Did you brief them on the electors and their supposed crimes?
I don't recall specific conversations, but I'm sure that in the course of briefing them, I discussed...
Wasn't that the purpose of the entire investigation as it was set out? Because putting aside that in 1960, as we already talked about, my friend Mr. Tiffany, that Hawaii put forward an alternate slate of electors, the investigation pivoted to President Trump and frankly, anybody who knew him. Do you know who Cleta Mitchell is?
Yes, I do.
She's an election lawyer that was involved in filing an election contest on behalf of President Trump in Georgia in December of 2020. A 64-page complaint with over 1,100 pages of exhibits, witness affidavits, and expert witness reports documenting thousands of votes cast in violation of Georgia law, but which were nevertheless included in the vote totals. Now, notwithstanding the disposition of the cases that was filed, is that a criminal act? Filing an election contest on behalf of a candidate for office, a client. Is that a criminal act, yes or no?
No, in fact, we stated...
So why did you deem it appropriate to monitor Cleta Mitchell's long-distance phone records in 2023, 2.5 years after the election contest was filed and after the presidential electors were certified? What about Jenna Ellis? What about Sidney Powell? What about Bill Sepien? What crime did you suspect had been committed by them that would warrant monitoring their phone records 2.5 years after the 2020 election was certified?
With respect to Sidney Powell, she is one of the co-conspirators alleged in the indictment. I don't know what you mean by monitoring, sir, if you're talking...
Well, there were some 400 plus Republican conservative groups and leaders who were targeted by your investigation. Their financial records were obtained, records of the RNC, the Trump campaign, Cleta Mitchell, the Conservative Partnership Institute, the America First Policy Institute, NRCC, NRSC, PACs, conservative groups, people all across the country, citizens, because we hear a lot about members of Congress. And we should, because of separation of powers and the egregious abuse of power. But what we're not talking about enough, in my opinion, are the American citizens that have been targeted. Because frankly, are there any limits to the power of a special prosecutor or special counsel? So much so in your abuse of power that in the summer of 2024, the indictment involving classified documents was dismissed after determining your appointment violated the Appointments Clause of the Constitution, but you continued to sign your name on court filings until the time you resigned from office in January of 2025. A federal judge just recently stated a prosecutor who continues to sign his name in court filings after a disqualification order should face disciplinary action or disbarment.
With respect to the last point, Judge Cannon's order specifically limited her finding to that proceeding, so there would be nothing improper about continuing to litigate the cases in Washington, D.C., and with respect to Florida, there was nothing improper about taking an appeal of that very decision.
The political war over federal law enforcement has hit an absolute flashpoint on Capitol Hill as a high-stakes congressional hearing turned into a direct, personal confrontation over the outer limits of executive power. Tensions inside the House Judiciary Committee completely boiled over when Texas Republican Representative Chip Roy confronted former Special Counsel Jack Smith with newly uncovered internal documents. The fiery exchange stripped away all traditional legislative decorum, exposing a deep institutional battle over secret subpoenas, political surveillance, and allegations of systematic lawfare targeting American citizens. Representative Roy went on the offensive immediately, revealing an email that proved his own long-distance phone metadata had been swept up by federal prosecutors under a probe codenamed Arctic Frost. He slammed the discovery as an egregious abuse of power and a direct violation of the separation of powers, pointing out that his records were targeted because of his communications with fellow lawmakers like Pennsylvania Representative Scott Perry. Roy aggressively detailed how he had no idea his data had been handed over by AT&T until just weeks prior to the hearing, arguing that the lack of notice completely prevented lawmakers from objecting or asserting legislative privileges. The confrontation quickly broadened into a scathing indictment of the entire special counsel probe into the 2020 election. Roy used his time to outline what he characterized as an unrestricted, weaponized dragnet that targeted more than 400 conservative groups, political committees, and prominent legal figures. He specifically grilled Smith on why the Department of Justice deemed it appropriate to monitor the long-distance phone records of election lawyer Cleta Mitchell, alongside figures like Jenna Ellis, Sidney Powell, and Bill Stepien, years after the election had already been legally certified. Roy demanded to know what specific crimes could possibly warrant monitoring an attorney for filing a standard election contest on behalf of a client, flatly asking whether there are any operational limits left to the power of a special prosecutor. But the former special counsel refused to yield an inch, meeting the intense congressional interrogation with a calm, deliberate defense of his office's integrity. Facing accusations of deep partisan bias, Smith maintained that his team pursued its investigation without any personal or partisan loyalties. Addressing the phone records directly, Smith clarified that the subpoenas in question had actually been issued by federal prosecutors before he was ever appointed as special counsel. He pushed back against the characterization of his work, clarifying that figures like Sidney Powell were specifically named as unindicted co-conspirators in the criminal indictment, which legally justified the scope of the evidence gathered. Smith also unswervingly defended his decision to keep signing court filings after a Florida federal judge dismissed the classified documents indictment in the summer of 2024. When Roy accused him of violating judicial standards and facing potential disbarment for continuing his legal filings, Smith coolly countered the narrative. He pointed out that the dismissal order was strictly limited to that specific Florida proceeding, making it entirely proper for his office to continue litigating its active cases in Washington, D.C., while simultaneously filing a legitimate legal appeal to reverse the Florida decision. As the testimony played out live, the fallout rippled far beyond the hearing room. President Donald Trump took to Truth Social, aggressively attacking the proceedings and stating he hoped Attorney General Pam Bondi was closely looking into Smith's past actions. When questioned about the heavy political pressure and social media backlash, Jack Smith remained steadfast. He firmly stated that such public posts were explicitly meant to intimidate him, but doubled down on his record, calmly asserting to the committee that he simply would not be intimidated.